Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
The following narration is based on an actual decision of the Supreme Court. Names and identifying details have been changed to protect the privacy of the complainant. Anna started working as a customer associate in 2009 at a branch of LBC Express-VIS in Cebu. The branch team leader and officer in charge, Arturo, acted as her immediate superior. In the course of her employment, Anna noticed that Arturo often flirted with her, which made her uncomfortable. It started with Arturo staring and smiling at her, which later progressed to him touching her hand or putting his hand on her lap, even her shoulder. Over time, Arturo's behavior escalated into sexual harassment. Anna recounted occasions when Arturo would pull the strap of her bra, dismissing the act as a joke when she confronted him. She also claimed that Arturo once joked about having a baby with her. The final straw happened one day when Arturo sneaked up behind her, held her on the hips, and attempted to kiss her on the lips twice, succeeding on the second time. Anna reported the incident to the LBC head office, where management advised her to request a transfer to another team while it investigated the matter. She also submitted a formal complaint to the LBC head office and filed a report with the police. Sensing that management was not acting on her complaint, Anna resigned, saying that she was forced to quit as she no longer felt safe at work. More than 2 months after Anna filed her formal complaint, LBC held an administrative hearing regarding the incident. On the same day, Anna filed a complaint for illegal dismissal against the company. What acts constitute sexual harassment in a work environment? And do employers in the Philippines have a legal and moral obligation to prevent it? More importantly, can an employer's failure to act on such complaints result to its liability for constructive dismissal? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 1st of August 2025, and today we talk about the responsibility of employers in addressing sexual harassment complaints and whether their failure to act promptly and sensitively to such complaints can lead to liability for constructive dismissal. These within the context of the case of LBC Express-VIS Inc. versus Palco, GR number 217101, penned by Supreme Court Senior Associate Justice Marvic M.V.F. Leonen and decided by the court on February 12, 2020. And joining us to talk about this case is Branch 70 Regional Trial Court of Taguig City Presiding Judge Bernard P. Bernal. Judge Bernal is also a Professorial Lecturer at the Philippine Judicial Academy. Hi, Judge Bernal. Welcome to the Supreme Court Podcast.
Hi, Attorney Mike. Good day. Thank you for having me here.
Thank you for having us in your office here in Taguig, Judge. Now, to start our discussion, let's clarify key concepts in this case. First off, what is sexual harassment and how is it committed?
Sexual harassment under RA 7877 or the Anti-Sexual Harassment Act of 1995 has been defined as work, education, or training-related sexual harassment committed by an employer, employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person who, having authority, influence, or moral ascendancy over another in a work or training or environment or educational environment, demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, request, or requirement for submission is accepted by the object of said act. There are actually 2 types of sexual harassment with respect to RA 7877, Attorney Mike. It would involve a work-related or employment environment, and that one wherein education or training environment is involved.
Let's try to distinguish, Judge, between the two. So there are 2 instances. For example, in a work environment, how can you say that there is sexual harassment?
In a work-related or employment environment, sexual harassment is committed when the sexual favor is made as a condition in the hiring or in the employment, re-employment, or continued employment of said individual, or in the granting said individual favorable compensation, terms, conditions, or promotion, even privilege at work, or the refusal to grant sexual favor results in omitting, segregating, or classifying the employee, which in a way would discriminate, deprive, or diminish employment opportunities or otherwise adversely affect said employee. This above acts would impair the employee's right or privilege under existing labor laws, or the above acts would result in an intimidating, hostile, or offensive environment for the employee.
So, Judge, in short, if it either creates a hostile environment or it benefits the employee as a result of the sexual favor.
Yes, or withholding of opportunities to the employee if the sexual favor is not granted.
And it's clear that this is between an employer and an
And an
employee.
employee. An important thing we have to consider or remember in RA 7877, there is an imbalance between the offender and the offended party. The offender should be an employer and the offended party should be an employee, or there is a teacher and student relation or a trainer or a trainee relationship between these parties.
So it's important to point out, Judge, that under this type of sexual harassment, there's an employer-employee relationship.
Yes, it's very important because that is the first type, which is a work-related or employment environment where sexual harassment can be committed. There's also what we have in educational or training environment where sexual harassment can likewise be perpetrated by an offender.
And this is between the trainer and the trainee,
Yes.
or
and-
the professor and the student.
Yes, it is committed against one who is under the care and custody or supervision of an offender, and the offender would be those engaged in education, training, apprenticeship, or tutorship, who is entrusted with the offended party. The sexual favors is made a condition to the giving of a passing grade or the granting of honors and scholarship or the payment of a stipend, allowance, or other benefits, privilege, or consideration, or when the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice, sexual harassment in the education or training environment is committed.
And what about the concept, Judge, of constructive dismissal? Is this different from the concept of termination of employment for just or authorized causes?
Yes, these are two different concepts. Constructive dismissal occurs when an employer makes an employee's continued employment impossible, unbearable, or unlikely, or has made an employee's working condition or environment harsh, hostile, and unfavorable, such that the employee feels obliged to resign from his or her employment. A common example of this would be the demotion of an employee or when his or her pay or benefit are reduced. However, constructive dismissal is not limited only to these instances. The gauge to determine whether there is constructive dismissal is whether a reasonable person would feel constrained to resign from his or her employment because of the circumstances, conditions, and environment created by the employer for the employee.
So in short, Judge, even if the employee resigns, but this turned out to be involuntary because of the conditions brought about by not giving in to a sexual favor, that can be considered constructive dismissal.
Yes. We have to note as you ask, the difference between a constructive dismissal and a just or authorized cause for dismissal. In the first type, constructive dismissal is initiated by the employee due to the employer's treatment. On the part of the authorized termination, this one is meted out by the employer. As to the nature of it, the constructive dismissal is essentially involuntary on the part of the employee, while just and authorized cause termination is voluntary on the part of the employer. A legal ground for the constructive dismissal is usually subtle, indirect, or coercive, while just cause termination is direct termination based on law, particularly Article 297 and 98 of the Labor Code.
And we know the grounds, for example, if there's a closure of business or there's a retrenchment that's approved by the Department of Labor.
Redundancy. And yes, if the employee violates the code of conduct, they can be removed by just cause by the employee.
And we're curious about constructive dismissal. What kind of behavior or non-behavior on the part of the employer can be construed to be constructive dismissal?
There may be constructive dismissal if an act of clear discrimination, insensibility, or disdain by an employer becomes so unbearable on the part of the employee that it could foreclose any choice by him or her except to forego his continued employment and just resign from work.
And this is exactly what happened in this case to Anna. At least that's her claim. But what were the circumstances that prompted her to first file a complaint, then eventually resign from her job at LBC?
In the case of Anna, she filed a complaint after enduring repeated acts of sexual harassment from her supervisor, Arturo, which escalated to him forcibly kissing her on May 1, 2010. Distressed and angered by the deeds of her supervisor, she reported the incident to LBC's head office on May 5. However, after receiving no immediate protective action and being advised merely to request a transfer, Anna resigned on May 14, 2010, citing an unsafe and hostile work environment.
And Judge, these acts, forcibly kissing, and there were many other acts that Arturo did to Anna, are these textbook examples of acts of sexual harassment at work?
Definitely, these are textbook examples of sexual harassment at work. Under RA 7877, there is sexual harassment when there is an unwelcome acts of sexual nature, such as remarks, yung mga touching, kissing, giving of sexual jokes, most especially pulling a bra strap, which were all done by Arturo against Anna in this case. This was also committed by a superior in authority, considering that Arturo held a supervisory position which made him part of the managerial staff. Also, it created a hostile, offensive, or intimidating environment that affected the employment of Anna with LBC. The Supreme Court in this case emphasized that the gravamen of the offense is not the violation of the employee's sexuality, but the abuse of power by the employer. Here, Arturo's behavior and the employer's failure to act promptly transformed her workplace into a hostile one, which forced her to resign, thus meeting the criteria of a constructive dismissal.
And how did the Supreme Court judge assess whether this constituted constructive dismissal? What circumstances did it consider in upholding the rulings of the Labor Arbiter, the National Labor Relations Commission, and even the Court of Appeals?
The Supreme Court, in finding that Anna was constructively dismissed, emphasized that her resignation was not voluntary, but the result of an intolerable and hostile work environment created by Arturo's repeated sexual harassment and the employer's inadequate response. In upholding the findings of the Labor Arbiter, the NLRC, and the CA, the Supreme Court considered the following circumstances. First, Anna's immediate supervisor, Arturo, repeatedly made unwelcome advances, such as touching her body, making sexual jokes, such as making babies with you, pulling her bra strap, and eventually successfully kissing her, forcibly kissing her, without her consent. These acts were serious, repeated, and clearly unwelcome, amounting to a textbook sexual harassment. Also, the Supreme Court took into consideration that Anna reported the incident to the LBC head office just 4 days after the most serious incident took place on May 1. She also filed a police blotter and submitted a formal written complaint showing that she did not tolerate the harassment that was being perpetrated by Arturo and sought institutional protection. Notably, the Supreme Court likewise explained in the decision that LBC did not take swift action on the complaint. It merely suggested a branch transfer and only conducted a formal hearing more than 2 months or 41 days after. The harasser was suspended only after Anna had resigned, showing a lack of urgency and seriousness on the part of LBC. After reporting the incident, Anna felt unsafe already, and she didn't feel that going to work was the best position or thing to do for her. She feared that Arturo remained in a position of influence and that she could no longer work in peace and with dignity. So I think the Supreme Court agreed with the Labor Arbiter, the NLRC, and the Court of Appeals that the resignation of Anna was not voluntary, but was compelled by LBC's inaction and the hostile environment that was created around her, forcing her to involuntarily tender her resignation.
And one interesting aspect of this case, Judge, is that Anna actually tendered her resignation, but the Supreme Court ruled the resignation was involuntary because it was driven by a hostile workplace or an intolerable work environment. So, how significant is this element in a sexual harassment case?
That is very important. The ruling of the Supreme Court's recognition that Anna's resignation was involuntary is crucial in any sexual harassment case. It shows that even if an employee formally resigns, it can still be considered constructive dismissal if the resignation was forced by a hostile or unsafe work environment. I have to emphasize that. Hostile or unsafe work environment, because this highlights that an employer remains liable if they fail to act on harassment complaints and victims do not lose their right to redress just because they resigned from the company.
And one other aspect here, Judge, is the power dynamics involved in the case. The Supreme Court, as you pointed out also earlier, the gravamen of the offense in sexual harassment is the abuse of power, not merely the sexual acts.
You are correct in saying that, Attorney Mike, because as the Supreme Court held, the gravamen of the offense in sexual harassment is the abuse of power and not mere the sexual act. By saying so, the Supreme Court emphasized that the core wrong is not just the inappropriate behavior, but the use of authority or influence to exploit or intimidate a subordinate. In sexual harassment, power dynamics play a central role. It often involves superior-subordinate relationship, where the harasser has the authority over the victim's job with respect to hiring, firing, or promotion, when the employer has influence over the work condition, kung saan i-assign or the evaluation, and when the offender has moral ascendancy such as a teacher to a student, a senior to a junior role. Because of this imbalance, the victim would feel pressured to tolerate the behavior out of fear of retaliation, losing his or her job, or missing out opportunities. The harasser exploits this power to coerce or even silence the victim, and making the conduct not just inappropriate, but an abuse of authority.
So in this case, Judge, LBC tried to place the liability solely on Arturo. It argued that it was Arturo, not the company, who created hostility in the workplace. And it also said that Arturo was a mere co-employee and not part of LBC management. So the first question here is, can an employer deny liability over acts of sexual harassment committed by one of its employees?
The answer is no, Attorney Mike. An employer cannot simply deny liability for the acts of sexual harassment committed by one of its employees, especially when the harasser is in a position of authority or influence over the victim. In one case cited by the Supreme Court, in this particular case of Anna, LBC versus Palco, the Supreme Court emphasized that the employer is only solidarily liable for damages with the perpetrator in case an act of sexual harassment was reported and it did not take immediate action on the matter. In this particular case, there was an unreasonable delay on LBC's part in acting on Anna's complaint. Despite her allegation, there was no showing that LBC acted on Anna's report before they issued Arturo's notice to explain. The formal investigation took 41 days to commence after the incident was reported. Likewise, LBC offered no explanation as to why it took another month before it held an administrative hearing for the case.
So in short, Judge, what responsibilities do employers have under the Anti-Sexual Harassment Act?
Under RA 7877, there are three main responsibilities that every employer should be mindful of. First is create a protective measure, create corrective mechanism, and accountability. When we talk about protective measures, this pertains to the promulgation of rules and regulations to prevent sexual harassment in their environment and adopt internal policies against sexual harassment in the workplace. It also involves dissemination and posting of their policy in a conspicuous location for all the employees to see. When we talk about corrective mechanism, this pertains to the creation of a committee on decorum and investigation, just like what we have in the Supreme Court, that is tasked to investigate complaints in a fair and confidential manner, recommend sanctions or actions based on the finding, and eventually take immediate an appropriate action once a complaint is received, because this would prevent any employee from feeling that the environment that she or he works in is no longer safe for him or her. Likewise, accountability steps in when the employer or the head of office is made liable for the damages if they know the harassment but failed to act on it, or they tolerated or ignored the harassment.
In this case, Judge LBC did not expressly deny the statement of its area head that he could not immediately act on Anna's case because there were no bruises nor witnesses. So what did the Supreme Court have to say on this excuse that supposedly the reason why they did not act is because it's hard to prosecute that case?
According to the Supreme Court, suggesting that a case is weak because there is no witness or bruising are highly insensitive to the victims of sexual harassment. In stating that sexual harassment case is hard to prove without witness or physical manifestation of force, employers discourage their employees from coming forward with sexual harassment incidents. It fosters an environment wherein the employees would feel that their word cannot be taken against the word of the perpetrator. To quote the Supreme Court, they said that indifference to complaints of sexual harassment victims may no longer be tolerated. Recent social movements have raised awareness on the continued prevalence of sexual harassment, especially in the workplace, and has revealed that one of the causes of its pervasiveness is the lack of concern, empathy, responsiveness to the situation. Many times, victims are blamed, hushed, and compelled to accept that it is just the way things are, and they should either just leave or move on. In the case of Anna, the Supreme Court found LBC Cebu's head office reasoning that no action was taken because there was no bruises or witness to be unacceptable.
And just it's important to point out that this incident actually happened before Republic Act number 11313 or the Safe Spaces Act took effect. And we will discuss this in our next podcast. But in this case, what lessons can employers derive as regards preventing or addressing instances of sexual harassment in the workplace, even in the absence of protections now provided under the Safe Spaces Act?
Even though the incident of LBC versus Palco happened before RA 11313 or the Safe Spaces Act was enacted, the case offers critical lessons for employers on how to prevent and address sexual harassment under existing laws like 7877. For employers, they should be reminded that they should respond promptly to complaints regardless of the presence of physical evidence or witnesses, and prevent any delay or inaction because it could lead to their liability in case of constructive dismissal and damages. Also, employers should never minimize or dismiss allegations, statements of there's no bruising or there's no witness shows insensitivity and the lack of understanding how sexual harassment usually occurs, often in private without any physical marks or any eyewitness, other than the perpetrator and the victim. Employers should establish clear internal procedure, such as creating a committee on decorum and investigation to handle complaints confidentially and fairly even before the Safe Spaces Act mandated it. Also, the employer should protect the victim. They must ensure that the complainant's safety and dignity is preserved, prevent any retaliation from the offender, and take interim measures like suspension of the alleged harasser or reassignment until the investigation is terminated. Lastly, employers are encouraged to foster a culture of accountability. This case of Anna shows that failure to act enables harassment and creates a toxic workplace, which can lead to liability on the part of the employer, even without newer laws like RA 11313. Bottom line is, even before the Safe Spaces Acts, employers had a duty under RA 7877 to proactively prevent and address sexual harassment. And this case of LBC versus Palco reminds employers that inaction is not neutrality, it is negligence.
And finally, to close our discussion, Judge, what should be the key takeaway from this case for both employees and employers?
For the employers, key takeaways in this case of LBC versus Palco would be that they have the legal and moral duty to create a safe and respectful workplace. Not all sexual harassment committed by an employee can hold an employer liable to the victim. Inaction or delay in addressing sexual harassment complaints can result in legal liability, reputational damage, and a loss of trust, even before the Safe Spaces Act. Laws like 7877 required immediate and appropriate action because silence or indifference enables abuse. As for the employees, a major takeaway would be that they have the right to a workplace that is free from harassment and intimidation. They should feel empowered to speak up, knowing that the law protects them, even when the harassment is subtle, private, or committed by someone in authority. Resignation does not mean forfeiting one's right, especially if it is driven by an abuse or if the employer neglects its duty to address the complaint. Finally, I just want to share, Attorney Mike, that sexual harassment is not just about misconduct. It is about the power and accountability of people. This case stands as a reminder that dignity at work is a right, not just a privilege, and that both employers and employees have a share in upholding it.
Very well said, Judge Bernal. Thank you again for joining us today.
Thank you for having me, Attorney Mike. It's my pleasure to be here.
Our pleasure to be here also. And to our listeners, if you wish to read the full text of the resolution of the Supreme Court, please visit the Supreme Court website, sc.judiciary.gov.ph, and search for GR number 217101, LBC Express-VIS Inc. versus Palco. Here is Tiff Atendido Beltran, Supreme Court Information Officer, for recent updates about the court.
From the Supreme Court of the Philippines, here's the latest. More than 150 successful examinees of the 2025 Sharia Special Bar Examinations are set to take their oath on Wednesday, August 6 at the Manila Hotel. 2025 Sharia Special Bar Examinations, or SSBE Chairperson Associate Justice Antonio Co. Jr. earlier announced that 154 out of 629 examinees, or 24.48%, passed the first fully digitalized special examinations for the Sharia courts held on May 25 and 28, 2025. The Office of the SSBE Chairperson also released the names of the 10 successful examinees who obtained the highest grades. The successful examinees were reminded to complete the clearance procedure via barista from July 28, 8 o'clock a.m. to July 30, 5 o'clock p.m. On Friday, the Office of the 2025 Bar Examinations Chairperson, under the leadership of Associate Justice Ami Lazaro Javier, issued an advisory on required and permitted items at the local testing centers, or LTCs, for the guidance of the bar examinees. Single-use plastics will not be allowed in all LTCs for this year's bar examinations. The full list of permitted and prohibited items may be found on the notice dated August 1, 2025. The Supreme Court has ruled that the Philippine government's share in the profits from the Malampaya Natural Gas Project includes the income taxes of its private contractors. In a decision written by Associate Justice Japar de Maampao, the SC En Banc lifted the charges against Shell Exploration BV, PNOC Exploration Corporation, and Chevron Malampaya LLC for unpaid income taxes. The SC reversed the ruling of the Commission on Audit, citing Presidential Decree No. 87, or the Oil Exploration and Development Act, which states that income taxes paid by or on behalf of contractors are included in the government's guaranteed 60% share of net proceeds from petroleum operations. The SC clarified the tax assumption is not tax exemption. The contractors are still liable for income tax, but the government pays it on their behalf as part of its share in the project's income. The SC added that it respects the arbitral ruling of the International Chamber of Commerce in line with the state's policy favoring arbitration. In another case, the Supreme Court has affirmed the authority of the National Labor Relations Commission, or NLRC, to execute the terms of a collective bargaining agreement, or CBA, in cases involving unfair labor practices. The SC's 3rd Division, through Associate Justice Japar de Maampao, upheld the NLRC's order directing Guagua National Colleges, or GNC, to pay its employees the agreed economic benefits, but adjusted how those benefits were computed. The SC clarified that while voluntary arbitrators generally handle CBA implementation, the Labor Code authorizes the NLRC to enforce CBA provisions when gross violations amounting to unfair labor practices are involved. The SE said that in this case, it was the NLRC which was best positioned to enforce the CBA, having reviewed it. However, the SE ruled that the computation of benefits should exclude the signing bonus and cover only the 5-year CBA term. In another case, the SE has clarified that being listed in a corporation's General Information Sheet, or GIS, is not enough to prove that someone is a stockholder. In a resolution written by Associate Justice Ramon Paul Hernando, the SE's First Division granted a motion for reconsideration of its earlier decision and ruled that Maria Cristina Patricia Lopez and John Rastilito Lopez are not stockholders of LC Lopez and Conqueror, despite being listed in the two companies' GIS submitted to the Securities and Exchange Commission. In granting the motion, the SE clarified that the stock and transfer book is the primary and official record of a corporation's stockholders. A person must also present a stock certification issued in their name to prove ownership of shares. In another decision, the SE has upheld a company's decision to suspend an employee who blocked access to the software he created while working there. In a ponencia by Associate Justice Samuel Garlan, the SE's Third Division held that JGC Philippines Inc., or JGC, validly placed Santiago Ciliano, a senior engineer, under preventive suspension while investigating his actions. Under the Labor Code, an employer can preventively suspend an employee without pay for up to 30 days if the employee's presence poses a threat to the company or its property. In this case, JGC had good reason to suspend Ciliano. At the time, the company believed it owned the software, as the Intellectual Property Office had not yet ruled on this matter. Ciliano's act of blocking access posed a threat to the company's property. The suspension also complied with the 30-day rule. Finally, SE Associate Justice Josep Lopez urged the graduates of the Lyceum of the Philippines, or LPU College of Law, to be ready to sacrifice comfort, reputation, and favor in their pursuit of justice. During the graduation ceremonies held on July 26, 2025, at the LPU Manila campus, Justice Lopez spoke about fortitude by sharing his journey of perseverance even after he faced many rejections. He also stressed how listening and questioning one's belief is important in the pursuit of truth. Finally, he called on the graduates to dedicate themselves to service and to use the law for the good of others and the nation. You're now up to date with the Philippine Supreme Court. I am Tiffany Doubletran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rimpilio, and May Sibal as researchers, Brian Austria, Don Ryan Balza, Lawrence Olanyo, Austin Aliscad, and Bea Batong as audio and video editors, and Tyke Flores and Jerome Batumalaki as web editors.